International Criminal Court are always a joy to my heart. As you probably already heard, I'm John Washburn. I'm convener of the American NGO Coalition for the International Criminal Court, which is a program of the Institute for the Study of Human Rights at Columbia. And having delivered that mouthful, we'll get going. What I want to do with this, since it's just me, I decided not to invite other panelists because we're talking about an institution. And if you have the institution chopped up into different bits from the perspectives of different people, you get an incoherent final picture of what the institution is. And so I decided to do this on my own. That raises the question of your having to listen to my voice going on for quite a while. And so what I'm going to do is I'm going to talk about in three segments. I'm going to describe the ICC for you so that we'll all be starting from the same point. Then I'm going to talk about the ICC and peace, and finally about the U.S. position on the International Criminal Court and what we can do to advance that, promoting the court, strengthening the U.S. position with the court as the work of my organization, as you will have seen from the handouts. And I'm going to stop at the end of each segment for discussion and questions and answers on what was in that segment. And then I will also make sure that we have plenty of time, we've got a 2-hour window here, we have plenty of time at the end for a general discussion and further questions and answers. I hope that we can get into a kind of at some point during this, into a kind of a seminar format in which we are talking back and forth with each other in a discussion and not simply a back and forth on questions and answers. But let me start by describing the court. The court is new or a subject of skepticism to a lot of people in the peace movement, which is one reason I was particularly pleased to see that it has a section in this excellent publication, and that my organization is named in that. However, the section needs being brought up to date, and I will be corresponding with the authors to make those corrections. The International Criminal Court was created by a treaty negotiated at the UN as a UN negotiation. It is now independent, but it has close relations with the UN, and it has been in effect, in operation since 2002, and has just moved into a beautiful new custom-built building on the dunes outside The Hague. It tries only human beings, those human beings most accountable for the very worst atrocities that are committed. Some people are disappointed that it doesn't try or doesn't address corporations directly. You can address a corporation only really in a civil proceeding because it's a legal person, not a human person, and you can't lock it up or put it in prison. All you can do is fine it. And for a lot of corporations, the fines are never large enough to really hurt. One of the court's basic principles is that atrocities and the damage that atrocities do to the prospects for peace and the ability to achieve peace, which atrocities hamper and stand in the way of, those things happen from the actions, the policy, and plans of human beings. So if you want to reach a corporation which is, for example, dispossessing tribal peoples in the Amazon, you go for the leaders of that organization, the officials of it, which are creating a plan or policy which displaces these people. In the peace movement, we often think, basically because our focus is on war, we think in terms of governments and nations. Actually, as the Nuremberg tribunals established way back at the end of the Second World War, in the end, the prime movers, the beginners, the first domino, if you want to put it that way, are people who choose to create atrocities, to take steps that bring about war. And this is why at Nuremberg there was a new crime committed called the crime against peace, aggression. There is now a movement, which I think is likely to succeed, to put the crime of aggression, the crime against peace, within the jurisdiction of the court, so that when that happens, it will be atrocity crimes which themselves create war and prevent peace, which can be already tried at the court under its current jurisprudence, which is war crimes, crimes against humanity. Will be added to this the crime of planning and developing acts of aggression, crimes against peace. The court gets jurisdiction in a couple of ways over these people. A person can be tried by the court if he or she is a citizen of a country which has become a state party to the court's treaty, or if he or she, whether or not the citizen of a state party, commits a crime on the territory of a state party. Now, right here is where the U.S. gets sensitive, because although the United States is not a state party and probably won't be for quite a while, we have soldiers operating now, soldiers and senior military people, generals, operating now in a country which is a state party, which is to say Afghanistan. And the court's prosecutor is examining the situation in Afghanistan to see if crimes have been committed there, which would be within the jurisdiction of the court. Now, crimes can be presented to the court by referrals. That would be a referral from a country which is a state party, a country which is not a state party but has made a special declaration to make this possible. And please come right in.
Thank you. I just have a couple announcements for you.
Oh, yes, go ahead.
As the moderator or facilitator of the group, we would like you to compile whatever comes out of this room and some sort of tangible report that
I've already communicated with David about
you
that.
have. Okay,
Yes.
wonderful. The other thing is, please fill out your blue evaluation forms. And the last thing is, does everybody know where the K building is, where the next event is?
No.
Okay, it's across campus, directly across campus in a round building. I'm told you can't miss it, which means, of course, I won't find it. But I'm told it's quite easy to find it, just across the quad. Okay, thank you.
Those go from 1 to 2 then.
No, that starts at 2. This session is 2 hours long, and that will be 2 to 4, and that's the planning for the nonviolent action tomorrow. And it's also where the Sam Adams Award ceremony will be at. Yeah, thank
The
you.
Sam Adams Award is also going to be in the K
In the
building?
K building, yes.
So after 2, this is the end of this building.
That's right. That's right. Thank you.
Okay, I was saying that we can have referrals from countries of a case to bring it to the court's attention, from a country that's a state party, from a country that is not a state party that makes a special declaration to make that possible. Referrals are also made by the United Nations Security Council. We've already had 2 of those having to do with Sudan and Libya. The United States abstained on the first of those referrals, which is done by a resolution, and supported the second one. And this reflects a theme in the U.S. position on the court, which I'll be talking about later. The UN Security Council may also call on the court to defer action on a case for a year at a time. This request can be renewed annually, otherwise it expires at the end of the year in question. This is a provision which makes it possible for, if the UN Security Council or some other recognized effort is underway to achieve a peace settlement somewhere, and believes that taking up a case against someone important to that settlement will stand in its way, it can ask the court not to drop the case, but simply to defer action on it until the future. This is the big issue which I know a lot of you have had a chance to address in your work, which is the issue of whether there is a conflict between peace and justice. And in my segment on peace, I will get back to that. But I'm setting the stage now for these as soon as I finish this segment, sir. The court offers the persons that it tries all of the due process protections that are in the United States Constitution, with the exception of not providing a jury trial. This question of a jury trial was extensively discussed in the negotiations to create the court's treaty, and it was decided that it was not going to be possible to create a jury of peers to try somebody like Hitler or Idi Amin or any of the other major atrocity committers, Bashir of Sudan. There's no way to put together a jury which would look reasonable and acceptable and fair, and it would be better to leave this to professional judges. And of course, in the United States, we have a great many criminal trials in both the civil system and the military justice system, which are conducted by and decided on by judges and not by juries. We also, in the United States, extradite American citizens regularly to countries that do not offer jury trials. So the absence of a jury trial, although at first blush may seem like a real departure from what we are used to, in fact, it is not all that exotic to us in our own legal system. For many of you, it will be of special interest that the Rome Statute calls on the court to make special care provisions for victims and witnesses who are victims. There is a provision to provide participation in trials for victims, either in person or through representatives. It has provisions for reparations to victims through a separate victims trust fund. This is a very important but very difficult activity which the court is still struggling with. And the care for victims includes making it possible, particularly if they are witnesses, for them to bring their families, to help them provide places to stay, and for psychological care and counseling as they participate in the trials. In the case of witnesses who have been deeply traumatized, there are technical arrangements which makes it possible for the witness, the traumatized witness, to see the defendant, but not for the defendant to be able to see one-way glass and so forth. For the defendant not to be able to see the victim, so the victim witness knows that she is not being seen. At the same time, to protect due process, the identity of the witness must always be known to the defendant and his counsel, to preserve the right of the defendant to know who his accuser is and not to be subject to accusations by anonymous persons. So there's this balance in the operation of the trials, which is important to the court and to its future and to its viability and legitimacy. I will be talking more about that in terms of the ICC's contribution to peace, but it is very important that the court be seen, even if it is difficult for some of the victims and witnesses. It's very important for the court to be seen as authoritative and as absolutely fair, because a large part of the court's contribution to peace derives from its moral standing as well as its legal standing. Okay, I should just mention that the court now has 124 member states. The United States, China, and Russia are not among those. Neither is Israel or India. And one of the reasons why we have this program to bring the U.S. closer and closer to the court, and eventually when the time comes when the politics is right, to go for ratification by the U.S. of the court's statute, is precisely so that the U.S. will not only serve its own values and the values of all of us, its citizens, in participating in this court, which Americans and civil society have already contributed so much, but also so that it will serve as the icebreaker for other large and powerful countries. Just to give you an idea, all European countries, all the members of the EU are members of the court. Almost all Latin American countries are members of the court. Most African countries are members of the court, and although Asia has been very slow in producing members of the court, we are beginning now to get momentum there, and it looks as though Bangladesh, Myanmar, and several other countries will join. Japan became a state party some time ago. Okay, this is the end of the first segment, describing the court, and I'd like to take your questions, thoughts, comments. You had your hand up, sir.
When you said that you really can ask the court to defer a case for a year,
Yes.
can the court refuse to defer?
No, it can't. And I should mention that when it's a question of a referral, the court can decide whether or not to accept that referral. But when it's a deferral, we have a political judgment by the court, by the UN Security Council, that a time is needed to achieve a settlement before persons involved in negotiating the settlement are tried or charged by the court. That's a political judgment. That judgment needs to be made outside the court, which needs to remain purely non-political. There's no absolutely pure non-political. As the saying goes, judges read newspapers too. But to minimize the political influence on the court. Yes?
So that deferral can be renewed,
Annually, but it has to be done each year.
but it could go on for 20 years?
It can go on, yes.
What is the
This
reason
price we pay,
for it?
just a minute, ma'am. Yes, that's the price we pay. Yes, ma'am.
I'm not sure why, I couldn't hear you when you first addressed the
Yeah.
issue. What was the reason for a deferral? Because to me, if you're deferring something for 20 years, Pinochet or one of those people will be dead and buried. So what is the reason?
The reason for it is that a decision that a peace settlement needs to go forward without an important actor in the peace settlement being charged by the court. That's a political decision. It needs to be made by a political body, and that's the Security Council. Now, it's technically possible for this to go on for a long period, but remember that the 5 permanent members of the court have a veto power over resolutions, including resolutions of deferral, and it is very unlikely that these resolutions would be repeated year after year for many years. Normally, peace settlements either make it or lose it within a couple of years.
Exactly.
Okay. Yes, ma'am.
Regarding the United States is not a member of the ICC, and what if you said that if the United States is committing acts within a member state, for instance, Afghanistan, so can Afghanistan bring the U.S. to court regarding that?
Yes, and furthermore, the prosecutor has the right to determine that a particular situation, which is in the jurisdiction of the court, should become a case of the court. The prosecutor has the independent ability to do that. So that is an additional way for a case to get to the court beyond the matter of referral.
And if the U.S., since it tends to just do whatever it wants, let's say that the prosecutor says, yes, the U.S., there's a high probability the U.S. committed war crimes, and they bring the case, how to do any consequences to the U.S. since they have not agreed?
Okay, first of all, let me be clear. We're talking about the U.S. this, the U.S. that. Actually, it's a U.S. individual.
George Bush.
It's a general. It's the Secretary of Defense. In certain cases, maybe even the President. Now, It is all international organizations, including this one, have difficulty having their orders or their requests carried out by individual countries. The countries that have become members of the court have assumed an obligation to carry out the court's orders. I don't want to fool you. In many cases, they don't do it. But their obligation is there. And because it's there, it means that a person who's been charged and has an arrest warrant against them from the court is in danger if he or she travels to any country which is a member of the court. They can never know whether when they get off the plane, the local police won't pick them up and deliver them to The Hague. Yes?
I have a question about the use of drones. Now,
You want to know whether drones can be a crime before the court?
well, and whether the individuals who mandate the use of drones can be held accountable for those drones being used in countries that have signed on to the international court.
Yeah, yes, the answer to that is yes. But be it noted that the crimes that the court tries are those that are of the utmost gravity and seriousness.
Who decides that, sir?
The judges of the court.
Okay. One of the issues that the Veterans for Peace, which is
Yes,
on my
yes.
mind, we have shied away from asking for impeachment of the current president, President Obama, and yet some of the issues about drones and other matters are parallel or greater than when we did ask for impeachment of
Okay, I follow you, sir.
So
The
would you
answer
talk
to where
about
you're,
that?
the answer to where you're going is it needs to be established first that the use of the drones has committed an atrocity which is within the jurisdiction of the court. So that's where it begins. It's not so much the instrument of how it's done. You can have 1,000 guys with machetes creating an atrocity, and you can have a drone doing it. You can have a nuclear strike doing it. If the atrocity is sufficiently grave, shocks the conscience of humanity, as the treaty says, then it qualifies for the jurisdiction of the court. I had a question back here somewhere. Yes, go ahead, sir.
Yeah, so does the treaty then, it does have its own separate code?
Yes, the treaty has an extensive section on jurisprudence which lays out in great detail the content of crimes against humanity, war crimes, and genocide. And when aggression, as I expect it will, becomes a crime, in the jurisprudence section, that too will be laid out in great detail.
Are the jurists assigned only to this court?
Yes, the judges serve this court only, exclusively. We're not have to live in the place where these horrible acts against them, their suffering, occurred. They have to walk down the street and see people from the group that did these things to them on the street also. They have to buy bread from a baker who may belong to the group that oppressed them. But having this truth told, having the sense of redemption, makes it possible for them to do that. Now, this doesn't work for everybody. People are different. But it works for a large enough number of people to convince the representatives of 160 countries in the negotiations to create the Rome Statute to believe that this was an objective well worth achieving for moral, political, and legal reasons. Now, this doesn't mean that those lower level people, that we're talking generals and presidents and dictators and leaders, this doesn't mean that the lower level people necessarily get off the hook. What it does mean that local procedures, local processes, trials, whatever, truth and reconciliation commissions, have an abundance of authoritatively created evidence and material that they can use in their local proceedings to go after the guys who pulled the triggers, set off the bombs, and swung the machetes. And so this is a contribution by the court to justice and redemption, not only through its own procedures, but by the use of its output by amnesty organizations, truth and reconciliation organizations, and so on. There is also a feeling that somehow, I'm often asked, does the court do restorative justice? And restorative justice, of course, is an issue that's very much at work in our country now. The plain and simple answer to this is that if you have been gang raped, if you have seen your family slaughtered in front of you, if your home has been destroyed and you've been driven into exile and refugee status, you're never going to be the same person again. You cannot, no human agency can take you back to what you were before these things happened to you. But what can happen is that this process of redress and redemption, not restoration, but redress and redemption, can make it possible for you to go forward with your life as you are now, with all of the things that have happened to you, to go forward and make the best of the life that lies before you. And if you are responsible for children, if you're responsible for participation in the civil life of your country, the ability to do that is extremely important if permanent peace is to follow preliminary or temporary peace. Now, a number of the, also on peace, a number of the founders of the court hoped for deterrence, hoped that the court would contribute to peace by deterring actions the commission of atrocities that lead to war and violence. It's too soon to tell. The court's only been in operation since 2002, and it's only had about 6 completed cases. It's too soon to know authoritatively whether that's going to work or not. And we also know from our own domestic criminal processes that the issue of deterrence is very hard to know. One of the reasons that it's hard to know is that you have to prove a negative, that people did not commit murder or did not do crimes because they were deterred by the possibility of being tried and going to prison or being executed. We all intuitively feel that that kind of deterrence exists, that people do refrain from committing crimes because they're scared of going to prison. But it's very difficult to prove, and deterrence at the level of the International Criminal Court is equally difficult to prove. I think that, though, since the commission of atrocities, the planning and developing of a policy of atrocities is the result of consultations among powerful people and their advisors, that we may indeed come to learn from from records of those consultations or for participants in them, that in the end the dictator, the general, the president decided not to do this. Now, we do have some anecdotal evidence. Warlords in the Congo, after the court took custody of several of them and committed them to trial, warlords in the Congo began to ask UN representatives in the Congo, what do I have to do to stay out of The Hague? Now, this is a tiny anecdote. It's impressionistic, but we hope that it is indicative. We also, in particularly, hope that the crime against peace, the crime against aggression, which I mentioned, will deter people who are inclined to organize, plan, and develop a policy to commit aggression. Since aggression is a very major and broad act of state, it requires quite a few participants to put together a policy and strategy for it. And we may hope that those participants will come to feel that this is a dangerous thing for them to do individually and personally. And this is one of the strengths of the court. It makes people think, if I do this, what is going to happen to me personally as an individual? I will not have a government to hide behind. This is about me. And that is one of the court's great strengths. Okay, let me stop here and again take questions from you, discuss. Yes, ma'am.
Have any of the cases been, I mean, I understand warlords in the Congo, they're kind of easy people to go after. What about Western countries? I certainly don't think anything the US has, or else I would have heard about it, or the UK, or Qatar, or France.
Okay,
Any of those countries?
Actually,
Saudi Arabia.
actually, the cases against warlords were not all that easy to do because the collection of evidence in a country like the Congo is a very tough proposition. But there is a great concern that the court seems to be only taking African cases. Now, that has come about because those cases have been referred to the court by many of the countries concerned. And then we have the two referrals, Libya and Sudan, by the Security Council. There's an image out there that the court is going around picking on African cases to the exclusion of others, which is not the case. Except for one, all of the African cases that are being handled at the court right now are from referrals, from the countries concerned or from the UN Security Council. In many cases, a country will decide that a particular kind of case is too difficult for its legal system to deal with, or that it will, if they try it in country, it will create instability in a very fragile situation after there's been a major regime change, lots of reasons like that. Also, in some cases, a person will commit an atrocity in one country, which is a state party, and then take refuge in another country that's a state party. We had this recently with the case of a man who was responsible for the destruction of historic, cultural, religious sites, UNESCO World Heritage Site in Mali. He took refuge in Niger. When Niger became aware that they had this man, they didn't want to turn him back to Mali because they didn't feel that he had any chance of a fair trial in Mali. And so they, being a state party, they turned him over to the court. And the court brought charges against him. And when he heard those charges against him, he broke down and confessed, and he is about to be sentenced. This is how that kind of thing works. Now, to turn to your question about cases elsewhere, the court has, under preliminary examination, a large number of cases that are not in Africa. There's Israel-Palestine. There is Afghanistan. There is Iraq. There is the Ukraine. We don't know yet whether, as a result of these preliminary examinations, the prosecutor is going to decide that they have found ICC eligible cases and that there is the evidence available to prosecute them. But these are in the first formal stage of prosecutorial investigation at the court. And from this, there's a group of about 10 of these now. And from these, we can expect in the next year or two that there will be cases from outside Africa in the court. Yes?
You mentioned Palestine, Israel. Israel is not a member of the ICC. I believe Palestine is.
Mm-hmm.
Sure. So if Israel or another country
and goes to the judges to say, I want to conduct a formal on-site investigation, she will have charges against individuals, high-ranking individuals, on both the Palestinian side and the Israeli side. Now, the basis for jurisdiction will be that Palestine is now a state party. to the court. The Palestinian Authority has been accepted as a state party at the court, which means that the territory of Palestine is now the territory of a state party, and that atrocities committed there, or crimes or war crimes, such as, for example, the settlements, will be eligible, all other things being equal, to be handled by the court. It also means that the rocket attacks by Hamas against Israel and some of the other anti-Israeli activities involving violence are also likely to be the subject of charges at the court. So that's how that will happen.
But if Israel isn't a party to the court.
Israel's not a party to the court.
So then the court says, I want to interview this person in your military, and Israel just says no.
Well, that may happen.
So then that can't proceed.
Well, not necessarily, because a lot of people are involved in, for example, something like the settlement activity there's abundant evidence on that from the Israeli. This is a public policy of Israel. There's not going to be any trouble on evidence on that. Now, things that the Israeli government and the military are accused of having been done in Gaza, yes, you may not be able to, depending on how astute Israel is about this, the court may not be able to interview generals, but the acts that took place in and of themselves are very powerful evidence, and it's not going to be, it will not be possible to hide that the Israeli government brought about these acts. So it can be a big problem if you can't interview people, but often you can work around it.
Okay, that was actually a question. Thank you.
Yes. Yes, ma'am.
Yes, what sort of defense do the accused get? Do you have professional defense attorneys on
Yes.
board?
Yeah, what happens is there's an arrest warrant. The person who's the target of the arrest warrant, if the court gets lucky, is arrested and brought to the court. And immediately, within 24 hours, the person is brought before the pretrial chamber of the court that first makes sure that this is the right person, and then informs the person of the charges and tells the person that he has a certain period of time to develop a response, a rebuttal to the charges. Make sure that the person has adequate defense counsel. In many cases, the person in question has sufficient funds and knowledge to do that on their own. If they don't, the court will assist them to have defense counsel. There is a fund for defense counsel for indigent defendants, okay? And then there is a confirmation of charges hearing, which is comparable to our indictment, and the suspect can make his rebuttal to the charges, and the judges at that point decide whether the charges have in fact been shown not to be correct or effective, or that the charges in fact are sound and sufficient, and then in the latter case they bind the person over for trial by the trial chamber. So yes, that representation by counsel is very definitely a part of the picture. Yes, ma'am.
What about funding? For instance, in the Israeli-Palestine issue, of course, the United States gives around $13 million a day to the IDF. Would they be culpable then for those actions?
Who, the U.S.?
United States, yeah.
No, the United States is not a state party, and although it may have provided funds that assist Israel in conducting these acts, the connection is not close enough for the court to address it. You have to recognize that the court is dealing with large numbers of atrocities for which there is a specific person specifically responsible, and that's its focus. Yes, sir?
Would that be Netanyahu by any chance? I mean, would he be indictable or whatever the word is?
Well, I don't want to get into specific names here. Let me just say that the court will look at who is responsible for the plan or policy that brought about a crime like the settlements.
Thank you.
Yes.
When there's a conviction, then is prison sentences, decided upon, is the prison in The Hague or?
The Dutch are not interested in housing a large number of atrocity prisoners on their own territory. So what has happened is that a number of state parties have signed agreements to make their penal facilities available to the court, and they have also agreed that it's the court's terms of imprisonment and conditions of imprisonment that will control this, not the local law. Okay, let me go then to my final segment, which has to do with the U.S. position on the court. I'm not going to go back into all of the history. There's a very long historical background here. Let me just say that the court was created in 1998 in the diplomatic conference in Rome. The birthday is July 17, which is now International Justice Day, a recognized international day which we work hard to have celebrated across the United States. The Clinton administration voted against the adoption of the statute in Rome, but at the very end, the very last day, in the closing hours of the last day, the Clinton administration decided to sign the Rome statute. Now, signing doesn't, as most of you know, doesn't make you a party to the statute. What it does is that it is a commitment that you will not do anything to undercut the purpose of the treaty, to undermine it, to go against it, to make it impossible to implement. That's the commitment. That's a very important commitment in itself, and especially important in the United States, where for constitutional as well as political reasons, it's extremely difficult to get a treaty ratified. And all of you can think of horror stories like the Convention on the Elimination of Discrimination Against Women, which people from far right to far left in the U.S. approve of, but we can't get Congress to consent to it. Okay, so the signature was important. Then we had the Bush administration, which came in, was very hostile, and promptly deactivated the signature. I use the word deactivated deliberately because a lot of discussion about the signature is talks about unsigning or something like that, which gives you an image of somebody going into the UN building to the treaty section with a big bottle of whiteout or an enormous eraser, and that's not what happens. Under international law, if you've signed, you can notify the authorities responsible for administering the treaty that you no longer want to be bound by your signature, but that doesn't destroy the signature. It freezes it, it suspends it. So this means that a future administration could send another note to the authorities, which in this case is the UN Secretary General and his legal department, saying we wish again to resume the obligations of our signature, and that would reactivate it. So the signature isn't dead, it's in waiting, it's suspended. And one of the things that we're working, in my organization, working very hard to achieve, is to get this signature reactivated. And we hope that as part of his legacy, before Obama goes out of office, that he will do that. We've had contacts with the Obama administration, and we have not been turned down. There is very carefully wary, limited interest expressed in this. Okay, so we had the Bush administration. The Bush administration took a series of hostile acts against the court, which I can go into for those of you who are interested. It's quite a long story. And then toward the end, it began, after these very hostile activities, it began to soften. And we had some very interesting indications of this. We had the legal advisor in the Department of State saying the International Criminal Court is here to stay. We need to accept that and learn to work with it. We had senior people in the Bush administration at the end saying Much the cases and much of the work on these cases that the ICC is doing serve the national interests of the court, and we need to recognize that. And then toward the end of the Bush administration, we had this referral of the Darfur situation, and the U.S. in the court. We had the UN Security Council presented with a resolution to refer the question of Darfur, the case of Darfur, Sudan, to the court, and the U.S. did not veto it. It abstained, and the resolution was passed, and the court now has jurisdiction over the situation in Sudan, which is one of its most difficult and frustrating cases. So when the Obama administration came in, the immediate background was not one of pure hostility. It was one of this beginning softening of the outgoing Bush administration. And so the Obama administration, which, as we all know, was deeply committed to multilateral approaches to international affairs, was able to proceed with its desire to get closer to the court. And so right away, under some pushing from civil society in which I was able to participate, the State Department decided that it would start sending delegations to ICC meetings, which it was had the ability to attend, which it was permitted to attend. For example, the Assembly of State Parties of the court, which is its governing body. The U.S. is able to participate there as an observer state, even if it is not a state party, and it does. And because the U.S. is so powerful, it wasn't the 1-ton gorilla in the room, but it is the 800-pound gorilla in the room, and it still has a great deal of influence on what happens in these meetings, and it sends large, distinguished delegations to them. The Obama administration also began to identify early on cases that it believed were in the U.S. national interest, and to work with the Office of the Prosecutor in investigating those cases. And it is able to, there are legal restrictions which prevent the U.S. from giving money to the court, but it is able to provide assistance in kind. So it provides expertise, it provides overhead satellite imagery, which is very helpful for determining what is going on the ground, for identifying the location of the burial sites of victims of atrocities and so forth. So we have now a growing, close, and extending relationship between the ICC and the court. And it is the work of my organization to make sure that that continues. The Clinton administration is likely to be receptive to continuing it. Secretary Clinton has made a number of speeches about it's very unfortunate that we have not been able to join the court. She's made speeches about it. We're shooting ourselves in the foot if we oppose what the court is doing in cases that are in our interest, and so on. To wrap up here very quickly, Congress has been a source of opposition to the court. These legislative restrictions about money, for example, other restrictions on the relationship between the U.S. and the court were passed in Congress, particularly during the Bush administration. However, more recently in Congress, we have had laws which call on the government to be more active in particular situations, such as trying to track down and eliminate this cult in northern Uganda, the Lord's Resistance Army, such as the Sudan, such as the situation in the Central African Republic, and so on. These laws, which are calling on the government to be more active, to send special forces groups and so forth, usually refer favorably with endorsement to the work of the ICC on the same situations, on the same cases, because the Congress has determined that this is in the U.S. national interest. Moreover, we recently, a year ago, we had a piece of legislation which offers a reward of up to $5 million to persons who successfully facilitate the carrying out of orders and arrest warrants by, the language is, international criminal tribunals. And it is clear from the legislative history of this provision that the International Criminal Court is included in this. So we have a gradual momentum building in Congress, even given the political realities in Congress. The reason for this is that when people confront the reality of an atrocity, they cannot back away from it. It compels them to seek to do something about it, no matter what their political positions are. And this is something that we build on in my organization's work in Congress. We have a special coordinating group in Washington that does that, which I co-chair. Finally, American public opinion. We have been receiving startling results in polls going way back to 2010 and before. These polls, which are conducted by outfits like Pew and in recent years have been conducted with the sponsorship of the Chicago Council on Global Affairs, come up with numbers 60, 70%. The most recent poll was 72%, in which respondents say the U.S. should participate in the court. And when they say participate, what they're really talking about is the U.S. should be a member of the court. Now, this sounds terrific. The problem with it is that it's passive. People have this nice, warm, fuzzy feeling about the court. Obviously, a court that punishes people who create atrocities is something we ought to get involved in. But this does not this is not the kind of public opinion yet that drives the political process. So again, another activity of my organization is to work nationwide to turn this positive but passive strong support for the court into an aroused public opinion that will have an impact on what the government does. And that is ongoing, and that will continue to happen no matter what the next administration is like, because it has to do with what the American people feel and can be made to want to make happen. Okay, that's my last segment, and let's get into questions now and discussion about any part of this. Sir, back there.
So you have public opinion on your side. What it takes to turn that into action is something which brings that to the top of the agenda. So some big fight, something on the table to vote on. How do you get something on the table for Congress to vote on to get people to say you want this? Or
well,
something like that. I'm not quite sure if that's what you want to do, but how do you get there?
Well,
how do you start that process?
Okay. We want a lot more of this legislation about specific situations which the court is involved. We want to get more recognition in Congress about the fact that atrocities are happening around the world. We want that emotion generated by atrocities to push this kind of legislation. As approval of the ICC is repeatedly stated in Congress in laws that are specific like this, we can build that into a understanding of the value of the court as an institution, so that we can get from enthusiasm about what the court does to enthusiasm about what the court is as an institution. That's where we're trying to go. And we're starting to get there. And as I say, the ability to tell Congress that there is this support among the American people is very valuable, very important. Now, we link
the issue of peace to this, because we can show that where someone has been convicted of committing atrocities that have been generating violence, the violence tends to stop, and it's not only violence by the followers of this particular person who tend to disperse and disappear once he or she is out of the picture, but it influences other people as well. This is a long process, but people who are, like yourselves, in the peace movement are used to operating in the middle and long term, and that's what's going to happen with the court as well. Our ultimate goal is to create a situation in the U.S. where it will be possible to achieve ratification when the political circumstances are correct. And of course, there's much we can do to create those circumstances as well. I'm sorry, that was a rather long answer to your question. Yes, ma'am.
As an American, my main interest is seeing the United States foreign policy change and the atrocities that the United States government is committing. And I think when you said 72% of Americans approve, I think because of the media and how it leaves that out of the news, most Americans don't get that our own government is committing those atrocities. And how do you think that all coming out will affect things?
Well, I do a lot of speaking, and I do a lot of conferring with people in localities around the country, editors of local newspapers, academics who study their local situations as well as beyond. And I think that the recognition among the American people about what is wrong with Guantanamo, about things like Abu Ghraib, things like atrocities committed against prisoners in Afghanistan, is pretty well known among American people. And I think that their knowledge of that is one of the reasons why we now have this tremendous skepticism in the United States about government. And I think that the consequence of this will be either that the American public will be willing to tolerate an American being tried at the court once the atrocity that that person has committed is known, or that it will prompt the United States to improve its record and its processes for trying Americans who are responsible for atrocities. Now, this invokes something that I haven't mentioned before. I've tried to avoid getting into too much technical detail here, but this is one now that you have brought out, and that is that the court is required under the statute to defer to domestic criminal justice systems if they are fair and effective, and those systems are undertaking to try somebody who is a subject of interest by the court. This is called the doctrine of complementarity with an E in the middle. And the idea here is that one of the purposes of the court is to encourage countries around the world to undertake trials of atrocity people themselves. And in the very, very long run, the hope is that that will happen very widely around the world, and the need to use the court will substantially diminish. Long time for that. But so if we have an American general who is clearly responsible for atrocities, and the atrocities have been committed on the territory of a state party, giving the court jurisdiction, then the U.S. government, and an arrest warrant, for example, or an investigation begins, the U.S. government has the option of pursuing this person themselves, or of seeing the court do it, or at least of seeing the court issue an arrest warrant for this person, which identifies him as having done all these things, makes it impossible for him to travel in most parts of the world, and so forth. My guess is that when that happens, we will see an improvement in the record of the United States in going after very high-ranking people who are responsible for the commission of atrocities, rather than having them wind up at the court, or at least wind up as the subject of arrest warrants by the court. So it's, in the future, we can hope that it won't just be Lieutenant Calley being tried for the atrocities at My Lai during the Vietnam War, but that the generals who made him think that it was legitimate to do that, it was desirable to destroy that village, will themselves become much more liable to American judicial processes as well as to the court. I mean, this is in part a hope. You can't tell what's going to happen in the future, but it certainly is a reason that is an incentive for an awful lot of Americans working in this area like myself. Yes?
Your language indicates that you have a sense of an evolving global legal system, that this is the direction of humanity, to embrace more and more the idea of global courts in one way or another to resolve conflicts.
Yes.
And that's kind of in your, if I can use the word, your soul or your sense of the future. Am I?
Well, on other subjects which lack the emotional punch that atrocities do, that's kind of a rough way to say it, but that's the fact. It's going to be a lot harder to do this than it is to create a criminal court that will try people for these. I mean, at the end of the Second World War, we had this never again motto, and instead we've had it again and again and again and again. We've had over 100 million people suffer in smaller, in longer time frames and smaller numbers than the Holocaust, but to suffer the same kinds of things that people suffered during the Holocaust. And eventually people all over the world and governments got disgusted with this. And things like Rwanda and the former Yugoslavia, where we had temporary tribunals, made people realize that a criminal tribunal to try atrocities could work, could be established, and that instead of creating them over and over again for specific situations with all of the practical and operational drawbacks that creates, the thing to do is to have a permanent court. And I was in Rome when the statute was finally adopted. The representatives of 160 countries in this big conference room in the Food and Agriculture Organization building in Rome. And there was an outburst of joy and enthusiasm when the gavel came down on the adoption, such that nobody has ever seen before in the adoption of a treaty. The hugging, kissing, tears, embracing went on for almost an hour before people got tired and stopped. This was a very big moment expressing emotional and moral as well as legal feelings that people all around the world had and that their governments felt it necessary to represent, and whose government representatives found themselves wound up in this work. It was a big moment, a really big moment. I felt greatly privileged to be there to see it and to participate in it. And this goes on. Civil society now, the International NGO Coalition, which I am associated, my outfit is associated with, has 2,500 institutional members in almost all of the countries of the world, including Russia. And they work constantly to bring more countries in to participate in the court, to bring about the adoption of the Rome Statute jurisprudence into their own legal systems, and so forth. This is a triumph for international civil society, for the kind of civil society work that all of you belong to and are involved in, and it's going on and on and on. Yeah.
Could I just quickly ask you, you had said before that you were hopeful and that you were positive about the experiences that you've had in your travels and talking to the people
Yes.
that you've talked to. So let me ask you, for instance, have you talked to the veterans of foreign wars?
I've spoken to veterans groups.
Well,
And in particular, I've spoken to the American Legion and to the veterans of foreign wars. Yes, I have.
and you feel hopeful that some of them, the leadership of that group, those groups and others, that this has resonated with them?
Okay, you've got two things that work with veterans. You've got a very high degree of commitment to the United States. You've got, they're patriots. These are also people who have